First Schedule. Section 4. Part 1, Constitution of Office of Children's Advocate. 1. The Children's Advocate shall be appointed by the Governor-General by instrument, under the broad seal after consultation with the Prime Minister and the Leader of the Opposition. 2. 1. Subject to the provisions of subparagraphs 4, 2, 7, the Children's Advocate shall hold office until he attains the age of 70 years. 2. Nothing done by the Children's Advocate shall be invalid by reason only that he has attained the age at which he is required by this section to vacate his office. 3. Where by reason of illness, absence from the island or other sufficient cause a person appointed Children's Advocate is unable to perform his functions under this Act, he may appoint a member of his staff to perform those functions for a period not exceeding 2 months. But if the Children's Advocate is unable or fails to appoint such a person, or if it is necessary that such a person be appointed for a period in excess of 2 months, the Governor-General, after consultation with the Prime Minister and the Leader of the Opposition, may appoint such person as he thinks fit to perform those functions. 4. The Children's Advocate may be removed from office only for inability to discharge the functions of his office, whether arising from infirmity of body or mind or any other cause, or for misbehavior, and shall not be so removed except in accordance with the provisions of this section. 5. If each House of Parliament by resolution decides that the question of removing the Children's Advocate from office ought to be investigated, then a. The Governor-General, acting after consultation with the Prime Minister and the Leader of the Opposition, shall appoint a tribunal, which shall consist of a chairman, and not less than 2 other members, from among persons who hold or have held office as a judge of a court having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or a court having jurisdiction in appeals from any such court, and b. That tribunal shall inquire into the matter and report on the facts thereof to the Governor-General, and advise the Governor-General whether the Children's Advocate ought to be removed from office for inability as aforesaid or for misbehavior. 6. The provisions of sections 8 to 16 of the Commissions of Inquiry Act shall apply, with the necessary modifications, in relation to tribunals appointed under subparagraph 5, or, as the context may require, to the members thereof as they apply in relation to commissions or commissioners appointed under that Act. 7. Where the question of removing the Children's Advocate from office has been referred to a tribunal appointed under subparagraph 5, and the tribunal has advised the Governor-General that the Children's Advocate ought to be removed from office, the Governor-General shall by instrument under the broad seal, remove the Children's Advocate from office. 8. Where the question of removing the Children's Advocate from office has been referred to a tribunal under subparagraph 5, the Governor-General, acting after consultation with the Prime Minister and the Leader of the Opposition, may suspend the Children's Advocate from performing the functions of his office, and any such suspension may at any time be revoked by the Governor-General acting as aforesaid, and in any case cease to have effect if the tribunal advises the Governor-General that the Children's Advocate ought not to be removed from office. 3. 1. No person shall be qualified for appointment to the office of Children's Advocate if that person, a. is a member of the Senate, or the House of Representatives, b. is an undischarged bankrupt, or c. has at any time been convicted of any offense involving dishonesty or moral turpitude. 2. The Children's Advocate shall vacate office if any circumstances arise that, if he were not Children's Advocate, would cause him to be disqualified for appointment as such, by virtue of subparagraph 1. 4. A person appointed as Children's Advocate, a. shall be a full-time officer, and b. except with the approval of the Governor-General acting in his discretion, shall not be employed in any other capacity during any period in which he holds office as Children's Advocate. 5. When a vacancy arises in the office of Children's Advocate, the Governor-General, after consultation with the Prime Minister and the Leader of the Opposition, may designate someone to act in that office during such vacancy. until an appointment is made. 6. 1. The children's advocate shall receive such emoluments and be subject to such other terms and conditions of service as may from time to time be prescribed by or under any law or by a resolution of the House of Representatives, such emoluments being not less than the emoluments which may, from time to time, be payable to a Queen Judge. 2. The emoluments and terms and conditions of service of the children's advocate, other than allowances that are not taken into account in computing pensions, shall not be altered to his disadvantage during the period of his appointment or reappointment, as the case may be. 3. The emoluments for the time being payable to the children's advocate under this Act shall be charged on and paid out of the Consolidated Fund. 7. The provisions of Appendix A shall have effect with respect to the pension and other benefits to be paid to or in respect of a person who has held office as children's advocate. 8. 1. The children's advocate may appoint and employ for the purposes of this Act, at such remuneration and on such terms and conditions as may be approved by the Commission constituted under subparagraph 2, such officers and agents as may be considered necessary to assist him in the proper performance of his functions under this Act. 2. The Commission referred to in subparagraph 1, shall consist of a. The Speaker, as Chairman. b. The President of the Senate. c. The person designated by the Prime Minister as leader of government business in the House of Representatives. d. The person designated by the Leader of the Opposition as leader of opposition business in the House of Representatives. e. The person designated by the Leader of the Opposition as leader of opposition business in the Senate, and f. The Minister responsible for finance. 3. The Governor-General may, subject to such conditions as he may impose, approve the appointment to the staff of the children's advocate of any officer in the public service, provided that in relation to pension, gratuity, allowance and other rights as public officer, such officer shall be deemed to be in the public service while so employed. 9. Every person appointed to the staff of the children's advocate shall, before he performs any function assigned to him under or by virtue of this Act, take and subscribe an oath to be administered by the children's advocate, in the form set out in Appendix B. Schedule 1-Part 2 Functions of Children's Advocate 10. For the purposes of this part, relevant authority means a. A ministry, department or agency of government. b. A parish council or the Kingston and Street, Andrew Corporation. c. A statutory body or authority, or d. A company registered under the Companies Act, being a company which the government or an agency of government holds not less than 51% of the ordinary shares. Right means a right guaranteed by the Constitution of Jamaica or any other law. 11.1. The children's advocate shall, a. Keep under review the adequacy and effectiveness of 1. Law and practice relating to the rights and best interests of children. 2. Services provided for children by relevant authorities. b. Give advice and make recommendations to Parliament of any minister or relevant authority, on matters concerning the rights or best interests of children. 1. Upon request by Parliament, or such minister or relevant authority, as the case may be, as soon as is reasonably practicable after receipt of the request. 2. On such other occasions as the children's advocate considers appropriate. c. Take reasonable steps to ensure that 1. Children are made aware of the functions and the location of the office of the children's advocate and the ways in which they may communicate with the children's advocate. 2. The views of children and persons having custody, control or care of children, are sought concerning the exercise by the children's advocate of his functions under this part. 2. The children's advocate may, after consultation with such bodies and persons as he thinks appropriate, issue guidance on best practice in relation to any matter concerning the rights or best interests of children. 12.1. The children's advocate may provide assistance, including financial assistance, to a child in making a complaint to a relevant authority. a. The that the rights of the child have been infringed by any action taken by that or another relevant authority, or b. that the interests of the child have been adversely affected by any such action. 2. The children's advocate may act on behalf of a child in a. making a complaint referred to in subparagraph 1, and b. any investigation or other proceedings conducted by a relevant authority pursuant to the complaint. 3. Where the making of a complaint to a relevant authority is regulated by a statutory provision, nothing in this paragraph authorizes a complaint to be made to that authority otherwise than in accordance with the statutory provision. 13.1. Subject to the provisions of this paragraph, the children's advocate may conduct an investigation into a complaint made by a child that a. the child's rights have been infringed by any action taken by a relevant authority, or b. the child's interests have been adversely affected by any such action. 2. Where the children's advocate decides not to conduct an investigation into a complaint made under subparagraph 1, he shall prepare a statement of his reasons for that decision, and shall send a copy of the statement to a. the complainant, and b. the minister and such other persons as the children's advocate considers appropriate. 3. The children's advocate shall not conduct an investigation in respect of a. any action for which the complainant has or had 1. a right of appeal, complaint, reference or review under any other law, or 2. a remedy by way of proceedings in any court, unless the children's advocate is satisfied that, in the particular circumstances, it is not reasonable to expect the complainant to resort or to have resorted to the right or remedy. b. The commencement or conduct of any proceedings before any court or any international tribunal. 4. There shall be a written record of every complaint submitted under this paragraph. 5. A complaint under this section may be submitted orally or in writing by a. the child, his parent, guardian, next friend or person in loco parentis, or b. where the child is unable to act for himself by reason of infirmity, or for any other cause or has died, his personal representative, or a. member of his family, or any other suitable person. 6. Notwithstanding anything provided by or under any law where a complaint addressed to the children's advocate is made by a person who is an inmate of a government institution or is detained therein. a. It shall be forwarded to the children's advocate by the person for the time being in charge of the institution, and b. If such complaint is contained in a sealed envelope, the envelope shall be forwarded unopened. 14.1. Subject to the provisions of this paragraph, the children's advocate may in any court or tribunal a. bring proceedings, other than criminal proceedings, involving law or practice concerning the rights or best interests of children. b. Intervene in any proceedings before a court or tribunal, involving law or practice concerning the rights or best interests of children. c. Act as amicus curiae in any such proceedings. 2. An intervention under subparagraph 1b shall not be made except a. with the leave of the court or tribunal, and b. in accordance with the rules regulating the practice and procedure of the court or tribunal. 3. The children's advocate shall not bring, or apply to intervene in, proceedings unless he is satisfied that a. the case raises a question of principle, or b. there are other special circumstances which make it appropriate for the children's advocate to do so. 15.1. This paragraph applies to proceedings a. involving law or practice concerning the rights or welfare of children, which a child has commenced or wishes to commence, or b. in the course of which a child relies, or wishes to rely, on such law or practice. 2. where a child applies to the children's advocate for assistance in relation to proceedings to which this paragraph applies, the children's advocate may, subject to subparagraph 3, grant the application if he is satisfied that a. the case raises a question of principle. b. it would be unreasonable to expect the child to deal with the case without assistance because of its complexity, the child's position in relation to another person involved, or for some other reason, or c. there are other special circumstances which make it appropriate for the children's advocate to provide assistance. 3. The children's advocate shall not grant an application under subparagraph 2, unless it appears to him that there is no other person or body likely to provide such assistance. 4. Where the children's advocate grants an application under subparagraph 2, he may arrange for the provision of legal advice or representation, and any other assistance which he thinks appropriate. 5. Arrangements made by the children's advocate for the provision of assistance to a child may, if the children's advocate thinks it reasonable in the circumstances, include provision for the recovery of expenses from the child, or the child's parent or guardian. Part 3. Process of investigation. 16.1. Where the children's advocate proposes to conduct any investigation under this Act, he shall give to a. the principal officer of the relevant authority to which the investigation relates, and b. any other officer thereof who is alleged to have done or authorized any action referred to in paragraph 13L, a, or b. an opportunity to comment in writing on any allegations relating to such action. 2. The children's advocate may adopt whatever procedure he considers appropriate to the circumstances of a particular case and, subject to the provisions of this Act, may obtain information from such persons and in such manner, and make such inquiries as he thinks fit. 3. Nothing in this Act shall be construed as requiring the children's advocate to hold any hearing, and except as provided by subparagraphs 1 and 5, no person shall be entitled as of right to comment on any allegations or to be heard by the children's advocate. 4. Regulations made under this Act may prescribe the procedure to be adopted at any hearing, and such procedure may include provision to ensure that any communication is not disclosed at that hearing. 5. If it appears to the children's advocate during the course of an investigation that there are sufficient grounds for making a report or recommendation that may adversely affect any person, the children's advocate shall give that person an opportunity to be heard, and that person may, if he wishes, be represented at that hearing by an attorney at law or any other person. 6. Where, for the purposes of an investigation, the children's advocate requires a person to attend before him, that person shall be entitled to be paid, according to the scale laid down in the first schedule to the Witnesses' Expenses Act, expenses incurred by him by reason of such attendance and by way of compensation for the trouble and loss of time suffered by him. 7. After conducting an investigation under this Act, the children's advocate shall inform the principal officer of the relevant authority concerned of the result of that investigation, and if the children's advocate is of the opinion that a. the complainant's rights have been infringed by any action taken by a relevant authority, or b. the complainant's interests have been adversely affected by any such action. The children's advocate shall inform such officer aforesaid of the reason for that opinion and may, as he thinks fit, make recommendations for action to be taken by the relevant authority within a specified time. 8. Where the children's advocate has made a recommendation under subparagraph 7, and within the time specified or a reasonable time thereafter, he is of the opinion that no adequate action has been taken to remedy the injustice or infringement, he shall lay before Parliament a special report on the case. 9. The children's advocate shall not, in any report under subparagraph 8, comment adversely on any person unless he has given that person an opportunity to be heard. 10. Where the children's advocate is of the opinion that a. the complainant's rights have been infringed or interests adversely affected as mentioned in paragraph 13(1)(a), or b. the children's advocate 1. shall inform the complainant of that opinion, the nature of the infringement or adverse effect and the recommendations, if any, which have been made to remedy the matter, and 2. may make such comments in relation to the case as he thinks fit. b. the complainant has suffered no such infringement or adverse effect, the children's advocate shall inform the complainant of that opinion and the reasons therefor and may make such comments in relation to the case as he thinks fit. 11. On the conclusion of an investigation, the children's advocate a. make to the relevant authority concerned such recommendations as the children's advocate thinks fit and in particular, but without prejudice to the generality of the foregoing, may recommend any or all of the following. A. that the action which was the subject matter of the complaint be reviewed. b. the alteration of an enactment, rule or regulation which causes or may cause infringement of children's rights or have an adverse effect on the best interests of children. c. that compensation be made to the complainant. 12. If the children's advocate finds, during the conduct of his investigations or on the conclusion thereof, that there is evidence of a breach of duty, or misconduct, or criminal offense on the part of an officer or member of any relevant authority, the children's advocate shall refer the matter to the person or body of persons competent to take such disciplinary or other proceedings as may be appropriate against that officer or member, and in all cases shall lay a special report before Parliament. 17. 1. Subject to the provisions of subparagraph 9, the children's advocate may at any time require any officer or member of a relevant authority, or any other person who, in the opinion of the children's advocate, is able to give any assistance in relation to the investigation of any matter, to furnish such information and produce any document or thing in connection with such matter and which may be in the possession or under the control of that officer or member or other person. 2. Subject to the provisions of subparagraph 5, the children's advocate may summon before him and examine on oath a. any complainant, or b. any officer, member or employee of a relevant authority, or any other person who, in the opinion of the children's advocate, is able to furnish information relating to the investigation, and such examination shall be deemed to be a judicial proceeding within the meaning of Section 4 of the Perjury Act. 3. For the purposes of an investigation under this Act, the children's advocate shall have the same powers as a judge of the Supreme Court in respect of the attendance and examination of witnesses and the production of documents. 4. Any obligation to maintain secrecy or any restriction on the disclosure of information or the production of any document or paper or thing imposed on any person by any other law, including a rule of law, shall not apply in relation to the disclosure of information or the production of any document or thing by that person to the children's advocate for the purpose of an investigation, and accordingly, no person shall be liable to prosecution for an offence under any other law aforesaid, by reason only of that person's compliance with a requirement of the children's advocate under this Act. 5. No person shall, for the purpose of an investigation, be compelled to give any evidence or produce any document or thing which he could not be compelled to give or produce in proceedings in any court of law. 18. 1. Except in the case of proceedings for an offence under paragraph 23c, no proceedings whatsoever shall lie against the children's advocate or any person concerned with the administration of the office and functions of the children's advocate, for anything he may do or report or say in the performance of his functions under this Act. 2. anything said or any information supplied or any document or thing produced by any person for the purpose or in the course of any inquiry by or proceedings before the Children's Advocate under this Act, shall be absolutely privileged in the same manner as if the inquiry or proceedings were proceedings in a court of law. 3. For the purposes of the Defamation Act, any report made by the Children's Advocate under this Act and any fair and accurate report thereon, shall be deemed to be privileged. Part 4. General. 19.1. The Children's Advocate and every person concerned with the administration of the office and functions of the Children's Advocate shall regard as secret and confidential all documents, information and things disclosed to them in the execution of any of the provisions of this Act, except that no disclosure a. made by the Children's Advocate or any person aforesaid in proceedings for an offence under paragraph 23 or under the Perjury Act by virtue of paragraph 17(2) of this schedule. b. Which the Children's Advocate thinks it necessary to make in the discharge of his functions and for the purpose of executing the provisions of paragraph 16 or paragraph 21, subject as provided in sub-paragraph 5 thereof, shall be deemed inconsistent with any duty imposed by this sub-paragraph. 2. Neither the Children's Advocate nor any such person aforesaid shall be called upon to give evidence in respect of, or produce any document, information or thing, aforesaid in any proceedings other than proceedings mentioned in sub-paragraph 1. 21. The accounts and financial transactions of the Office of Children's Advocate shall be audited annually by the Auditor General, and a statement of accounts so audited shall form part of the annual report mentioned in paragraph 21. 2. The Children's Advocate shall, at such time within each year as the Minister may direct, a. submit to the Minister a statement of the accounts of the Children's Advocate audited in accordance with the provisions of subparagraph 1. b. Submit to the Minister for approval the estimates of revenue and expenditure for the financial year commencing on the first day of April next following. 3. In this paragraph, Minister means the Minister responsible for finance. 21.1. The Children's Advocate may at any time be required by Reports Parliament to submit thereto a report in respect of any matter under investigation by the Children's Advocate. 2. The Children's Advocate shall submit to Parliament an annual report relating generally to the execution of his functions and may at any time submit a report relating to any particular case or cases investigated by him which, in his opinion, require the special attention of Parliament. 3. Reports under this paragraph shall be submitted to the Speaker of the House of Representatives and the President of the Senate, who shall, as soon as possible, have them laid on the table of the respective houses. 4. The Children's Advocate may, in the public interest, from time to time publish in such manner as he thinks fit, reports relating to such matters as are mentioned in sub-paragraph 2, and any case which is the subject of a special report under paragraph 16(8) and 12, provided that no such report shall be published until after it has been laid pursuant to sub-paragraph 3. 5. The Children's Advocate shall not, in any report furnished under this paragraph, disclose or act upon any communication between a medical practitioner and his patient in their professional relationship, b. a minister of religion and any person consulting him in his capacity as such, or c. between an attorney at law and his client in their professional relationship, where such communication came to the Children's Advocate's knowledge during the course of an investigation under this Act. 22.1. Where the Children's Advocate decides to investigate a complaint, he shall cause to be recorded in a register kept for the purpose a. the subject matter of the complaint and the date thereof, and b. on the conclusion of the investigation, the Children's Advocate's decision respecting the complaint. 2. No entry in the register shall disclose the name of, or any other personal data relating to, the complainant, and any person may, on the payment of such fees as may be prescribed, inspect, during the hours and on the days of business of the Children's Advocate, any register kept pursuant to this paragraph. 23. Every person who a. willfully 1. makes any false statement to or misleads or attempts to mislead the Children's Advocate or any other person in the exercise of his functions under this schedule, or 2. fails to comply with any lawful requirement of the Children's Advocate or any other person under this schedule, or b. without lawful justification or excuse 1. obstructs, hinders or resists the Children's Advocate or any other person in the execution of his functions under this schedule. 2. fails to comply with any lawful requirement of the Children's Advocate or any other person under this schedule, or 3. contravenes the provisions of paragraph 13, 5, or c. in a manner inconsistent with his duty under paragraph 19(1), deals with documents, information or things mentioned in that subparagraph, commits an offense. 24. Nothing in this schedule shall be construed as limiting or affecting any remedy or right of appeal, objection or procedure given to any person by any other provision of law. 25. The Children's Advocate may make regulations for the better carrying into effect of the provisions of this schedule. 26. Where pursuant to any provision of this schedule, the Governor-General is required to act after consultation with the Leader of the Opposition and a. there is no person holding the office of Leader of the Opposition, or b. the holder of that office is unwilling, or by reason of his illness or absence from Jamaica, unable to perform his functions in that regard. The Governor-General shall act as if the reference to the Leader of the Opposition were a reference to such person as the Governor-General, in his discretion, considers appropriate. Appendix A. Pensions and Gratuities. 1. In this appendix, pensionable emoluments has the same meaning A in the Pensions Act. 2. 1. Where a person holding the office of Children's Advocate retires in pensionable circumstances, he shall, subject to the provisions of this appendix, be paid pension and gratuity in accordance with this Act in lieu of any pension, allowance or gratuity for which he may have been eligible or which he may have been granted pursuant to the Pensions Act or the Judiciary Act. 2. A person entitled to pension or gratuity pursuant to subparagraph 1 or who is eligible for a grant of pension or gratuity pursuant to subparagraph 5, may, by memorandum in writing to the Governor-General, elect to forego his entitlement under this Act and be granted instead a. if he is, otherwise than under this appendix, eligible for pension pursuant to Section 5 of the Judiciary Act, such award as would be payable under that Act if the office of the Children's Advocate were an office to which that Act applied, or b. in any other case, such award under the Pensions Act as would be payable under that Act if the office of the Children's Advocate were a pensionable office under that Act. 3. For the purposes of this paragraph and paragraph 4, a person retires in pensionable circumstances if a. he retires 1. on or after attaining the age of 65 years, or 2. by reason of ill health prior to such attainment, or b. he has a minimum of 10 years' service. 4. For the purposes of this Act, a person retires from the office of Children's Advocate on the ground of ill health if a. he retires on medical evidence, to the satisfaction of the Governor-General, that he is incapable by reason of any infirmity of mind or body of discharging the duties of his office and that such infirmity is likely to be permanent, or b. he is removed from office, in accordance with paragraph 27 of the first schedule, for inability arising from infirmity of mind or body, to perform the functions of his office. 5. A person who, pursuant to paragraph 27 of the first schedule, is removed from the office of Children's Advocate for misbehavior or for any other cause other than inability arising from infirmity of mind or body, or who retired otherwise than in pensionable circumstances, may, subject to subparagraph 2, be granted by the Governor-General, in lieu of any pension, allowance or gratuity for which he may have been eligible pursuant to the Pensions Act or the Judiciary Act, such pension and gratuity as the Governor-General thinks fit, not exceeding the pension and gratuity to which he would have been entitled, had he retired in pensionable circumstances from such office, and, for the purposes of subparagraph 6, the date of such removal from office or retirement shall be deemed to be the date of retirement in pensionable circumstances. 6. Pension payable in accordance with this paragraph shall be a. charged on and payable out of the Consolidated Fund, and b. paid monthly in arrears with effect, subject to paragraph 4, from the date of retirement in pensionable circumstances, and shall, subject to the provisions of this Act, continue to be paid during the lifetime of the person entitled thereto. 3. The rate of pension payable pursuant to paragraph 2 to any person shall be an annual rate equivalent to the sum of 1/2 of his pensionable emoluments at the date of retirement, and 1/360th of such pensionable emoluments in respect of each month of service as the Children's Advocate. 4. Where in accordance with paragraph 2(3) a person retires in pensionable circumstances before he has attained the age of 65 years. A. The date with effect from which any pension due to him under this Act shall be payable shall be the date on which he attains that age. But, if he elects pursuant to paragraph 5 to take a reduced pension and commuted pension gratuity, nothing in this paragraph shall prevent payment of the commuted gratuity at any time prior to the attainment of that age, and b. If he dies before attaining that age, and he has not made an election to receive a reduced pension and commuted pension gratuity as aforesaid, he shall for the purposes of paragraph 6 be deemed to have died while holding the office of Children's Advocate. 5. 1. Any person to whom a pension, in this paragraph referred to as the original pension, is payable pursuant to paragraph 2, may, at his option exercisable at his retirement in pensionable circumstances or within such period prior or subsequent to his retirement as the Governor-General may allow, be paid, in lieu of the original pension, a reduced pension at the rate of 3/4 of the annual rate of the original pension, together with a gratuity, in this Act referred to as a commuted pension gratuity, equal to 12 1/2 times 1/4 of the annual rate of the original pension. 2. The option referred to in subparagraph 1 shall be irrevocable unless the Governor-General, on such terms as he considers reasonable, otherwise permits. 6. 1. Where a person dies while holding the office of Children's Advocate, there shall be paid to his legal personal representative a gratuity of an amount equivalent to a. 1 year's pensionable emoluments, or b. the commuted pension gratuity for which the person aforesaid had a right to opt pursuant to paragraph 5 of this appendix, on the assumption that he retired in pensionable circumstances at the date of his death, whichever is the greater. 2. Where a person dies while in receipt of a pension pursuant to paragraph 2, there shall be paid to his legal personal representative a gratuity of an amount equivalent to 1 year's pensionable emoluments of that person at the date of his retirement or removal from office, from which gratuity shall be deducted any pension or gratuity already paid to that person under this Act or under the Pensions Act or under the Judiciary Act. 7. Where a person holding the office of children's advocate dies as a result of injuries received. A. In the actual discharge of his duties. B. In circumstances in which the injury is not wholly or mainly due to or seriously aggravated by his own serious and culpable negligence or misconduct, and C. On account of circumstances specifically attributable to the nature of his duty. While in that office, it shall be lawful for the Governor-General to grant to the deceased officer's widow, children, parents or other dependents such award as would have been made under the Pensions Act if the office of Children's Advocate were a pensionable office for the purposes of that Act. 8. A pension or gratuity payable under this Act shall not be assignable or transferable except for the purpose of satisfying a debt due to the government, or b. An order of any court for the payment of periodical sums of money towards the maintenance of the wife or former wife or minor children of the person to whom the pension or gratuity is payable, and shall not be liable to be attached, sequestered or levied upon for or in respect of any debt or claim whatever except a debt due to the government. 9. 1. For the purposes of the Pensions, Civil Service Family Benefits Act, the office of Children's Advocate shall be deemed to be a pensionable office, in the service of the island. 2. Where a person dies while holding the office of Children's Advocate or while entitled to a pension under paragraph 2, there shall be paid to his widow a pension at an annual rate equivalent to 1/5 of the pensionable emoluments of the person aforesaid at the date of his death, or, if at that date he was entitled to receive a pension under paragraph 2, at the date of his retirement or, as the case may be, removal from office in accordance with this Act. 3. Pension payable to a widow pursuant to sub-paragraph 2, shall a. Be charged on and payable out of the Consolidated Fund, and b. Be paid monthly in arrears with effect from the date of her husband's death and shall, subject to the provisions of this Act, continue to be paid during her lifetime. 4. Pension payable to a widow pursuant to sub-paragraph 2, shall be without prejudice to any pension to which she may be entitled under the Pensions, Civil Service Family Benefits Act, but shall be in lieu of any pension to which she may be entitled pursuant to Section 9 of the Judiciary Act. 5. In paragraph 7 and sub-paragraphs 2 and 3 of this paragraph, references to a widow shall, in the case of a female appointed children's advocate, be deemed to include references to a widower, and cognate expressions shall be construed accordingly, and similarly, references to a husband shall be deemed to include references to a wife. 10. Where a person retires without a minimum of 10 years' service, he shall be granted in respect of his service, the commuted pension gratuity for which the person had a right to opt pursuant to paragraph 5 if he admitted in pensionable circumstances, Appendix B, paragraph 9. Both to be taken by persons appointed to assist the Children's Advocate. I do swear that I will faithfully perform any functions assigned to me under the Child Care and Protection Act, and I will not, on any account, at any time whatsoever, except in so far as provisions of the Act authorize, directly or indirectly reveal any information or the nature or contents of my documents communicated to me in the performance of any functions assigned to me by virtue of the Act, so help me God.